Nobody, it seems, has actually read the bill who's mad about it. So you know what we're going to do? We're going to read the bill! Because I feel like we need to really look into this and see if it's half as bad. Spoiler alert, it's not, but we're just going to go through it anyway. An act relating to parental rights in education amending numbers and letters, requiring district school boards to adopt procedures that comport with certain provisions of law for notifying a student's parent of specified information. Legalese is not my first language. The fundamental right of parents to make decisions regarding the upbringing and control of their children in a specified manner, prohibiting the procedures from prohibiting a parent from accessing certain records, providing construction, prohibiting a school district from adopting procedures or student support forms, prohibit school district personnel from notifying a parent about specific information or that encourage or have the effect of encouraging a student to withhold from a parent such information, prohibiting school district personnel from discouraging or prohibiting parental notification and involvement in critical decisions affecting a student's mental, emotional, or physical well-being, providing construction, prohibiting classroom discussion about sexual orientation or gender identity in certain grade levels or in a specified manner, requiring certain training developed or provided by school districts to adhere to standards established by the Department of Education. So, okay, so far, here's what we've got. For those of you who are completely lost in what that just said, which I do not blame you, legalese is a very strange language. All it says at this point in time is you will be prohibited talking about sexual orientation or identity or sexualizing students, and you cannot introduce anything of that nature without first letting the parent know what's about to happen. That's pretty much the layout of what all that means right there. And also, the school cannot pass anything that states that they don't have to, like any policy. They can't pass any policy that states that they can leave the parent out of any kind of educational decisions. This is aimed to protect the parents' rights to basically have their kids learn what they think they should learn, which is common sense. This is a parent's child that you're talking about. This isn't your kid, it's their kid. You shouldn't be allowed to do anything without the parent's permission or express notification of the parent if you decide to do anything off script. Requiring school districts to notify parents of healthcare services and provide parents the opportunity to consent or decline such services. Again, putting parents in control. Providing that a specified parental consent does not waive certain parental rights. Requiring school districts to provide parents with certain questionnaires or health screening forms and obtain parental permission before administering such questionnaires and forms. You cannot hand the student something that has anything to do with health or ask them certain questions without first letting the parent know that this is going to be distributed to them. Requiring school districts to adopt certain procedures for resolving specified parental concerns, requiring resolution within a specified time frame. So you can't just let them know and then not get back to the parent is what I kind of take from that. So if the parent has an issue or something of that nature and they say, well, I don't want this, the resolution has to be done soon. It can't just lay there and fester and not go unanswered while you do what you want to do and then come back later. It's almost kind of like stopping the whole, ask for forgiveness rather than permission. Requiring the Commissioner of Education to appoint a special magistrate for unresolved concerns. Okay, if things are getting unresolved, somebody, a party comes in and helps to resolve these things. Providing requirements for the special magistrate, whatever he might need to help facilitate the resolution. Requiring the State Board of Education to approve or reject the special magistrate's recommendation within specified time frame. Okay. Requiring school districts to bear the costs of the special magistrate. Fair. Parents should not have to pay for this. And if they try to make parents pay, I guarantee you that's a smart thing to put in there. Because if the school districts really wanted to enforce things on the kids without the parents' permission, They could easily make it way too expensive for the parents to do anything. Requiring the State Board of Education to adopt rules, providing requirement for such rules, authorizing a parent to bring an action against a school district to obtain a declaratory judgment that a school district procedure or practice violates certain provisions of law. So bring the school to court. Providing for the additional award of injunctive relief, damages, and reasonable attorney fees and court costs to certain parents. This is good. So if the school screws up or they decide they want to try to screw up, they have to pay for everything. If the parent decides to take it to court, or multiple parents, they could break the school in half. So it makes it expensive for the school to screw up, which is awesome. Good. Requiring school district to adopt policies to notify parents of certain rights. Providing construction. Requiring the department to review and update as necessary specified materials by a certain date. Providing an effective date. Have you guys seen the word gay yet? Because I haven't. Still kind of, still searching for the... We're going to find the word gay, guys. Don't worry. It's going to be in here. Be it enacted by the legislature of the state of Florida, Section 1, Paragraph C is added to subsection 8 of section numbers and letters. Florida statutes to read... Powers and duties of district school board. The district school board, acting as a board, shall exercise all powers and perform all duties listed below. Student welfare. In accordance with the rights of parents enumerated in words and numbers, adopt procedures for notifying a student's parents if there is a change in the student services or monitoring related to the student's mental, emotional, or physical health or well-being, and the school's ability to provide a safe and supportive learning environment for the student. The procedures must reinforce the fundamental right of parents to make decisions regarding the upbringing and control of their child by requiring school district personnel to encourage a student to discuss issues relating to his or her well-being with his or her parent, or to facilitate discussion of the issue with the parent. The procedures may not prohibit parents from accessing any of their students' education and health records created, maintained, or used by the school district as required by the law. So, yeah, no secrets. That is what that boils down to, noob. This seems pretty straightforward so far, despite all the legalese, which, I mean, it's got to be airtight, because they will try to find, as Noob just pointed out, they will try to find a way around it. And after some time, they probably might, but you know what? It sounds to me like Florida legislature is going to be right there. You're like, oh, thanks for pointing that out to us. Gone. 2, a school district may not adopt procedures or student support forms that prohibit school district personnel from notifying a parent about his or her student's mental, emotional, or physical health or well-being, or a change in related services monitoring, or that encourage or have the effect of encouraging a student to withhold from a parent such information. So not only can you not keep secrets, you can't encourage the kid to keep secrets. School district personnel may not discourage or prohibit parental notification of and involvement in critical decisions affecting the student's mental health, emotional, or physical well-being, health or well-being. This subparagraph does not prohibit a school district from adopting procedures that permit school personnel to withhold such information from a parent if a reasonably prudent person would believe that disclosures would result in abuse, abandonment, or neglect, as those terms are defined. So, in other words, if they actually do see real abuse, and I'm talking about real abuse, because you have a lot of leftists out there going, it's child abuse to not let their kid be trans. You're trying to turn the kid into trans kid. Come on. Especially that young, they're not even thinking about sex and sexual identity. But I'm talking real abuse, starvation, beating, emotional damage that they're actually doing to the kid. You know, that's good. That's good for a teacher to act on. They should. Classroom instruction by school personnel or third parties. Still haven't heard gay yet. Classroom instruction by school personnel or third parties on sexual orientation or gender identity may not occur in kindergarten through the grade 3 or in a manner that is not age appropriate or developmentally appropriate for students in accordance with state standards. So that's the 3rd grade and down law right there. Can't teach them that stuff in this grade on down. Student support services training developed or provided by a school district to school district personnel must adhere to student services guidelines, standards, and frameworks established by the Department of Education. At the beginning of the school year, each school district shall notify parents of each healthcare service offered at their school, student's school, and the option to withhold consent or decline any specific service. Parental consent to a healthcare service does not waive the parent's right to access his or her student's educational or health records or to be notified about a change in his or her student's services or monitoring as provided by this paragraph. So they can decline a lot of services, but it doesn't mean that despite the fact that the services are declined, that they can't access anything, the parent. They still can. They still have full access to their students' health records. Any conversations that happen between counselors, nurses, anything. It's all right there. Before administering a student well-being questionnaire or health screening form to a student in kindergarten through grade 3, the school district must provide the questionnaire or health screening form to the parent and obtain the permission of the parent. Good. Each school district shall adopt procedures for a parent to notify the principal or his or her designee regarding concerns under this paragraph at his or her student's school, and the process for resolving those concerns within 7 calendar days after notification by the parent. At a minimum, the procedures must require that within 30 days, you know what it should be? I feel like there should be, you know, I like that better. And without asking for it, the parent should, I just want like a weekly update about anything. If my student is involved in anything, I want a weekly update as to what they're being taught, what's being said to them. If my kid had any interaction with a health professional or a nurse, mental health professional, anything. I don't care what it is. I want to know. And I want it included in that weekly letter that I get every single week. Every single week. At a minimum, the procedures must require that within 30 days after notification by the parent that the concern remains unresolved, the school district must either resolve the concern or provide a statement of the reason for not resolving the concern. Good. If a concern is not resolved by the school district, a parent may request the Commissioner of Education to appoint a special magistrate who is a member of the Florida Bar in a good standing and who has at least 5 years' experience in administrative law. The special magistrate shall determine facts relating to the dispute over the school district procedure of practice, consider information provided by the school district, and render a recommended decision for the resolution to the State Board of Education within 30 days after receipt of the request by the parent. The State Board of Education must approve or reject the recommended decision at its next regularly scheduled meeting that is more than 7 calendar days and no more than 30. After the date the recommended decision is transmitted, the costs of the special magistrate shall be borne by the school district. The State Board of Education shall adopt rules, including forms necessary to implement this subparagraph. So if the school doesn't get it right, the school doesn't do what they're supposed to do, special magistrate comes in and resolves it quickly, and the school pays for it. Bring an action against the school district to obtain a declaratory judgment that the school district procedure or practice violates this paragraph and seeks injunctive relief. A court may award damages and shall award reasonable attorney fees and court costs to a parent who receives declaratory or injunctive relief. Each school district shall adopt policies to notify parents of the procedures required under this subparagraph. Nothing contained in this subparagraph shall be construed to abridge or alter rights of action or remedies in equity already existing under the common law or general law. By June 30th, 2023, the Department of Education shall review and update as necessary school counseling frameworks and standards, education practices, and professional conduct principles, and any other student services personnel guidelines, standards, or frameworks in accordance with the requirements of this act. This act shall take effect July 1st, 2022. That's the entire thing. Where was the word yay? Did anybody hear it? Did anybody hear that? Did I skip over it somewhere? Let's go ahead and do a little word search. Gay doesn't come up. It's highlighted in red. No word gay here. Folks, it's almost like we're being lied to. What? How could this possibly be? We're being lied to? The hell you say? Yeah, it almost seems like the left is coming up with this don't say gay nonsense as a way to make people hate a bill that gives parents the right to say no to gender, to grooming. We're just going to say that. To say no to grooming. That's what this really is at the end of the day.